Good evening, this is John Milburn for Laws 12067 Environmental Law. This is week 1 of term 3, 2017. We have a few people who have joined us live. Thank you for doing so. We have some people, no doubt, who will watch this recorded session later. If you can join us live, please do so. I like to make it interactive if possible. My sessions won't necessarily go for a full hour. So you do have recorded sessions that I have presented to you on Moodle, primarily around the textbook. The textbook is Bates. It's very good, Environmental Law in Australia. However, it's lengthy, it's detailed. Those of you who haven't yet acquired your copy, I'll show you the size of the text. Sorry, but it is very good. What I have done is gone through chapter by chapter and recorded sessions of about 20-25 minutes where I summarise the important parts of the chapter and give you some idea of what I think you should take from the chapter. Now, I did those recordings a couple of years ago when we were on the 8th edition, so we now have the 9th edition, but the chapter numbers have changed, but the content, whilst of course it's been supplemented, is largely the same. So you will be able to follow my recordings by reference to the conversion chart that I've put on Moodle. So don't be too daunted by that textbook. You don't have to read every word. Move through it relatively quickly, get a feel for where it's going. What I plan to do during this course is, I hate to say this, supplement that lengthy text with other materials that are perhaps more practically orientated. So I'm very keen to show you things that you will need in practice if you practice in environmental law. Some idea of how the process works, and we'll be looking at some of those things tonight in terms of where you go to find precedents, for example, and get an idea of the practice directions and the way in which the Planning and Environment Court in particular works in Queensland. Now, those of you that are studying elsewhere, for the purposes of the exam, feel free to replace any reference to Queensland with a reference to your state or territory. I'm very keen to ensure that what you draw from this course is relevant to you and is practical for you. So I'm happy for you to present your answers to me based on a different jurisdiction, but just make it very clear that that's what you're doing. Okay, of course, in environmental law, we have the federal jurisdiction, we have the state jurisdictions, and we have international law as well. So that comment that I make about making it relevant to you obviously applies to anything that's to do with state and territory. Okay, as always, I'll commence by saying some good news, bad news issues. Good news is that the Planning Act in Queensland 2016 was made into law this year. So you're at the cutting edge. By studying environmental law now, you're coming in at a good time. The Planning Act is very important in terms of environmental law context, and you have an opportunity to begin learning it when others are learning it, even those that have practiced in the area for some time. With the Planning Act, we have the Planning Regulation also, which is 2017, so you'll need to be aware of that. And we have the Planning and Environment Court Act 2016. The Planning Act replaces the Sustainable Planning Act, which was 2009, and that in turn replaced the Integrated Planning Act. So as you read through the case law, as you read through the text or the materials, you will often see reference to legislation in Queensland that is now superseded. So if you see the Sustainable Planning Act or the Integrated Planning Act, just be aware that that is now not current law in terms of legislation. You need to look at the Planning Act, and you need to look at the Planning Regulation, and you need to look at the Planning and Environment Court Act. Okay, what do I mean by that? Because the Planning Act is so new, there's not much case law on it, if any. So the case law that you read that relates to planning and environment in Queensland will necessarily refer to legislation that is now superseded. So be prepared to make that adjustment. Also, the fact that the Planning Act is much smaller than the Sustainable Planning Act. However, the government was a bit tricky on this. The government introduced the Planning Act and said, we are going to simplify planning law and we are going to make the Act, which was very bulky, much more streamlined. But what they did was moved some of the material from the Sustainable Planning Act into the regulation, and they moved a whole lot of it into the Planning and Environment Court Act. So it's there, but it's now sort of separated into different areas. So rather than necessarily making that simplified, in some ways it makes it a little more complex. But don't worry, it's not that complex. And we'll be talking about those pieces of legislation as we proceed. Okay, as usual, those of you who've worked with me in the past, you'll know that as we proceed through these sessions, week by week, I encourage your questions or your comments. You can ask questions by simply unmuting my microphone or using the chat facility. In the meantime, I don't see any questions, but if you do have any questions, please ask. This week, I plan to talk about the assessment and some other practical aspects. Again, those of you that have worked with me in the past, you know that when it comes to questions on a week-by-week basis, I encourage you to ask through UCrew. Rather than send me an email or phone me, I'd rather you ask the question on UCrew. A few reasons for that. The first is that any response that I give is then available to everyone in the class to consider. So there are issues to do with equity. The second, and this is really important, is that very often the response that you might receive to a question or a problem that you're facing can be answered by one of your colleagues, and sometimes much better than I can do. So the UCrew encourages a collaborative approach. And I'm very keen on collaboration. Now, bear in mind, collaboration is not collusion. That's where we draw the line. But collaborating is terrific, and I encourage it. Essentially, I would love to see this group go through together, supporting each other throughout the process. So when it comes to the assessment pieces, from my perspective, when you're dealing with my classes, I'm happy for you to chat about them. Don't be scared to do that. Don't be afraid to have discussion groups or even mention things or ask questions about assessments on UCrew. But you'll understand if you ask me one-on-one for some response to an assessment piece, then I start to feel uncomfortable. But when it's collaborative, when we're all involved in it, that's fine. So I hope you understand that distinction. Okay, no questions so far? We have a very large textbook. We have a lot of material to cover. I'm going to supplement it with other material. So let's make a start. The first thing that I want to do is bring to your attention a quote that I think is appropriate for environmental law. I've mentioned the Planning Act. The two go together. Planning and environment normally work in conjunction with each other. And the way in which that's described appropriately is by Jerry Bates. At paragraph 14.93 in the 9th edition, he says, unless protection of biodiversity is linked with planning and development, then the regulatory authorities responsible for biodiversity management and protection are fighting a losing battle. So if in studying environmental law, your main focus, your main interest, your main attention is to do with issues to do with the protection of biodiversity, protection of the environment, bear in mind that quote, that it's linked very closely with planning and development. And it's also very closely linked with the powers that are conferred upon regulatory authorities that are, as Bates says, responsible for biodiversity management and protection. So everything's linked in. Let's just briefly talk about that. We have the separation of powers. Who can tell me about the separation of powers? And I should just say, I can see some chat facilities. I am getting a sign saying that my internet is unstable. Sorry. So if you're having trouble hearing me, it's my end. I'm told that where I live, where I work, will be much better connection in the near future. Okay, separation of powers. Who can tell me all about it? If you answer, then I don't have to pick on you later. All right. Separation of powers. How many powers? 3? 3. All right. Legislation. Commonwealth and states. So we know that's the first branch, the legislative. Parliament makes the legislation. At a Commonwealth level, where does Parliament draw its ability, Commonwealth Parliament, draw its ability to make environmental laws? Any thoughts? Tricky question. Okay. Yes, Christy?
It has to rely on powers broadly. There's nothing specific in the Constitution which allows them to make environmental laws.
Exactly. I suspect that when the Constitution was first made, nobody even thought about environmental law. So environmental law is a brand new subject. So it's not in there. And in the 80s, there were many cases involving the Commonwealth and the states where in the High Court, where pretty much the Commonwealth won all of them. So a leading case, for example, is the Tasmanian Dams case in the 1980s. Before that, it was the Murphy Oils case in the 70s. The Commonwealth was attempting at that stage to introduce legislation that had an environmental impact. The states went to the High Court saying, Commonwealth has no power to make laws in relation to the environment. So the Commonwealth, Christy, as identified it, looked at its more broad power base and justifies environmental lawmaking on that basis. What's the principal piece of environmental legislation at a Commonwealth level? Can anyone tell me the name of the act that I'm thinking about? EPBC. Yep. The Environmental Protection and Biodiversity Conservation Act. I call it the EPBCA. So if you hear me sort of rattling off EPBCA, 1999, that's it. That's what I mean. So it's an odd thing, isn't it, that we have a piece of Commonwealth legislation called the Environment Protection Biodiversity Conservation Act, and the Commonwealth has no power at all in the Constitution to make any laws about environmental protection and biodiversity conservation. But there we have it. So the history of it is, and you can read about this in the study guides and you can read about it in Bates, the history is that the 70s and 80s, Commonwealth were taken on by the states. They were beaten in the High Court. The Commonwealth beat them in the High Court. Then in the early 90s, we had this thing called COAG, where the Commonwealth, the states and other agencies came together. I think 92 might have been in Brisbane, and essentially said, look, let's stop fighting about this. Let's acknowledge that the Commonwealth does have powers and responsibilities to make environmental law-based legislation, and that is primarily the EPBCA. So you've got to have a look at the EPBCA. If you haven't already done so, do that now. Not right literally now, but do that now, if you know what I mean. It's a very lengthy piece of legislation, so I want you to go through and just get a feel for it. It's really important, and you will need that for your exam. Which brings me to another digression. Often I will give you hints about the exam. Those that have worked with me in the past, you know when I say something about the exam, make a note of it. Keep a folder, keep a document or something. So you've got to know the EPBCA for the exam. Not in detail, please don't read it all. It'll drive you crazy. It's too much. But get a feel for it, understand where it fits. Okay, so that's the main piece of environmental law legislation at a Commonwealth level. We know that the Commonwealth doesn't have power under its constitution to make that piece of legislation. We do know that there was a cooperative arrangement between the Commonwealth, the states and other agencies, COAG, in the early 90s, which paved the way for the Commonwealth to bring in that legislation in the late 90s. So we know that. But many of the concepts, the ideas, the principles that are included and embedded into that Commonwealth legislation actually come from somewhere else. The Commonwealth didn't necessarily make these things up. The Commonwealth didn't make up the precautionary principle or the intergenerational equity principle. Where did those principles and concepts come from? Common law? Maybe, but not the answer I'm looking for. Thank you, Justice. Anyone else want to tell me where, for example, the precautionary principle comes from? International treaties. Thank you, Jazz. That's it. So when you look at Commonwealth legislation, EPBCA, do so knowing that above it, we have international law, international public law. And we have the treaties, we have the conventions, we have all those things at an international level, which then filter down and are manifested in the EPBCA and other pieces of Commonwealth legislation. And then it filters again, it filters further. So we now see in state legislation reference to, for example, the precautionary principle. It all filters down from international law, international treaties. So just be aware of that chain. So when we talk about the separation of powers, we usually think about the three, and there are the three, but above that, arguably, we have international law as well. Okay, so just get a feel for where all this is going. At a state level, Queensland, can anyone name, apart from the Planning Act and the Planning and Environment Court Act, can anyone name another important piece of environmental law-based legislation? You can unmute or use the chat facility. Vegetation Management Act, thank you very much. The Environmental Protection Act, the first one 99, second one 94. I'll take your word for that. Sometimes I forget the Nature Conservation Act. That's it? Great. So there aren't that many pieces of legislation that you need to be familiar with, but for the purposes of the exam, make sure that they're bookmarked or whatever it is. Who downloads legislation in PDF and then highlights and makes comments? You do that? That's a good practice sometimes. Clinton says, yeah. So no, Jazz doesn't. But, you know, it's a good idea to do something like that with this, because there aren't that many pieces of legislation. So give yourself some way of accessing the material quickly and have it marked in such a way that helps you. Quick poll. Where do most people access state legislation? What platform do you use? There's probably 6 ways to get to any particular piece of state legislation. What do people do? How do you find legislation? Ausley, Legislation Queensland. I reckon it's a Legislation Queensland. I reckon it's a 1-for-1 vote. They're the two I go to as well. I know there are plenty of other platforms through LexisNexis, Westlaw, etc., but I typically go to the free, publicly available ones. If you were going to produce something from a piece of legislation and hand it to a judge in a court case, would you draw it? Would you print something from Ausley or Legislation Queensland? Legislation Queensland, yes. Okay. Yep. Why would you do that? Why not Ausley? Because it looks prettier? I don't know. It's an authoritative source. Thank you, Jazz. Okay, so you'll be aware that sometimes the courts, there are practice, sorry, I gave away the answer to the next question. Why do we hand up something which is an authoritative source? The answer is because it's in the practice directions to do so. Same applies to cases. So if you draw a case from Ostley, it won't be necessarily authorised, but you may have to go to the authorised reports. Those of you that have worked with me in Introduction to Law, you'll know how to find the authorised reports. The Queensland reports, for example, are authorised reports. The CLRs are authorised reports. So just keep that in mind. Okay, so far we've talked about legislation, Commonwealth, state. We've talked about how international law sits above it, and many of the concepts filter through both Commonwealth and state legislation. It's all pretty simple, really. Then, of course, we have the case law, which is the third branch of the separation of powers, the courts. What's the one in the middle? What's the second branch? This is really taking you back to basics, isn't it? But it's really important. So we've got Parliament making legislation. We have the courts that interpret the legislation and create the common law. What's the other one? Sort of like the three tenors, isn't it? Pavarotti, Domingo, and who's the other third one? Executive. Thank you, Clinton. That's what I was after. So when we talk about the executive, we're really talking about, in environmental law, we're talking about departments, aren't we? Departmental officers, they're the executive. They're not Parliament, they don't make the laws, they're not judges, but they have a role to play. Let's go back to that quote from Bates that I read at the start. Unless protection of biodiversity is linked with planning and development, then the regulatory authorities responsible for biodiversity management and protection are fighting a losing battle. So who are the regulatory authorities? What branch? Yep, the executive. Department of Natural Resources Management, Department of Environment, Heritage Protection. Yep, they're all regulatory authorities. They're all part of the executive. So when you're reading these cases, when you're reading the textbook, I want you to bear in mind those basic distinctions so that you know where the regulatory authorities fit into the equation. So we need to understand how regulatory authorities go about their business, don't we? Okay. In terms of the exams or the assessments that you need to fulfill, the first one, from memory, it's a while since I wrote it, but the first one I think relates to reviewing a case. We'll have a look at it shortly. So that's case law, judges, and also probably a statute. So the first one, Parliament, legislation. That's what I usually do for the first assessment in environmental law. The second assessment, I usually look at it from the perspective of the executive. So the second assessment will relate to how the executive deals with an application that involves, if I can say, heavy duty environmental law processes. And the third one, well, that's the take-home paper or the at-home paper. We'll talk about that shortly as well. Okay. Any questions then about where our environmental law comes from and how it fits together? We've talked about it for 15 minutes and now I expect you to be experts on all those things. All good? All right, great. We can do this. If you have any problems, where do we ask? We ask in UCrew. If you come across something that would be of great benefit to others, we check on UCrew as well. Have you got access to the landing page in Moodle for environmental law? Okay, I'm just going to share the screen so we can have a look at it together. I hope that I share the correct screen here. Can you tell me if you're now looking at the Moodle page? give us a nod. Is that what we're looking at? Great. Okay. So just quickly, those of you who've worked with me together in the past, you'll probably be aware of how this is set up and what we do. So thank you for joining us for these sessions. Latest information, that's where I'll put certain material. You'll see there's some greyed out bits that probably you can't see. There's greyed out bits here. That's the lecturers. I have the ability to grey things out. There's nothing fancy about that. That's just the assessment pieces. I've just put them in the assessment block on the top left-hand corner. The assessment material is here. So that's the actual assessment work that you need to do. And for the second assessment, there are other documents and links that you need to access in order to complete the task. I have those links outside of the assessment because I had a problem last term with SharePoint, which is what I use. It just wasn't. It didn't like being embedded in the assessment task, so I've kept that separate. I have some assessment guides, which are things that I like you to think about when you're preparing your assessment, and then of course we have additional resources, which are mostly including some links that might be useful. So we'll have a look at some of those tonight, briefly. But firstly, the assessment tasks. So we go to the top left corner. The first task due on the 11th of January. You've got plenty of time for this. 25%. Want you to read a case and answer some questions. You'll find number 1, number 2, and number 3 really simple. Number 4 you will find extremely difficult. So, number 1, just tell me some background to this case. Number 2, explain the legal rules. Number 3, apply the law to the facts. That's just straight IRAC that you learn in Introduction to Law. But number 4, this is the hard one. Okay, so what we're saying in this case is Her Honour Judge Boskill, who was at the time a district court judge and is now a Supreme Court judge, made a decision in the case of Whitsunday Regional Council against Brandbid. So that's all very well. But what if your client lost in that case and came to you and said, I want to appeal this decision? What would you have to do if your client asked you to do that? I want you to appeal the decision. I'm not happy. The decision, firstly, is the Planning and Environment Court. What would you do? Any thoughts?
Probably review the Planning and Environment Court principles. Sorry, I can't remember if there's an act for it or not. And see what is necessary and available in terms of being able to lodge an appeal.
Yes, that's a good point, because you can't always assume that you have a right to appeal. You may need leave to appeal. If you were to appeal a decision of the Planning and Environment Court, what would be the appropriate appeal court to hear that matter? The Land Court? No, I'm not so sure about that one. Which is a polite way of saying no. Supreme Court, we're getting closer, but which division of the Supreme Court? District? No. District? No. So Christie's right, it's the Supreme Court. But how many divisions of the Supreme Court are there? I'll give you a hint. There's 2. Appeals, yes. So we've got the trial division of the Supreme Court. We have the appeals division. So it would go to the Supreme Court, the Court of Appeal. Where does the Planning and Environment Court fit in the hierarchy of courts? It's off to the side a bit, isn't it? We're familiar with the Magistrates Court, the District Court, the Supreme Court. Where's the Planning and Environment Court sit? District. Oh, well, I'm not sure I can take that answer, Justice. When you put District Court with a question mark, that's yes, it is the District Court. No, I'll accept that answer. Are the judges who constitute the Planning and Environment Court separate judges to the District Court? No, correct. Well, yes and no, but primarily no. I say yes and no because judges do receive a commission to work in planning and environment, even though they're district court judges. The same way that they do for children's court matters, they need a separate commission. But essentially, the Planning and Environment Court is part of the district court. It's part of it, but it's not. It's quite separate, has its own legislation, but those judges that constitute the district court the Planning and Environment Court are district court judges. So not every district court judge will necessarily hear matters involving planning and environment, but many of them do. And go on the court's website and just see the list of judges in the district court that deal with planning and environment court matters. So just so you know the hierarchy, the P&E court, which is really important in this area of practice, of course, and most of the cases that you read at a state level will be from the P&E court, is part of the district court. The land court is quite separate. The land court is kind of on its own thing. So the president of the land court is President Kingham, who was a district court judge. So, there's certainly a lot of parallels there. So the question is, kind of like the family law court being part of the federal court, again, it's separate. The family law court is separate to the federal court. There's a closer link between the Planning and Environment Court and the District Court than there is between the Family Law Court and the Federal Court. Anyway, a few little nuanced things, but that's where it fits in. So coming back to our first assignment, I'll share the screen. How on earth are we going to answer this question, and what does the question mean? Can you see the question there? I've got 3 screens. I've got to make sure I show you the correct one. Right, so number 4, assume that the unsuccessful party consults you, wants to file an appeal against Her Honour's decision. Assume that you're within time to do so. Provide a short advice to the client explaining the appeal rights and the process upon which you could file an appeal in the Court of Appeal. I've even told you the answer, where you go. You are to attempt to identify at least one arguable basis upon which you could apply for leave to appeal to the Court of Appeal. Oh, I've given you another thing. I've told you that you need to seek leave to go to the Court of Appeal. Identify and explain the documentation required to do so, the likely time frame, and the cost associated with doing so. Provide your client with some advice with respect to costs ramification of proceeding unsuccessfully. Now, this really highlights the difference between the excellent material in Bates and the other material that I propose to show you during this course. So that's why I can't afford to allow you to spend all your time reading Bates. It's great, but you're not going to get the answer in Bates. Do you understand what I mean? You'll get the concepts, you'll get some ideas from Bates, but when it comes to practice and things like how do you actually make this work, you'd probably get more guidance from this sort of book, which I'd urge you to get, although it is being replaced at the moment. And it's this one, the Community Litigants Handbook. This is produced by the Environmental Defender's Office, and while it covers the same type of content as Bates' book, it does from a completely different perspective. So I'm going to teach you from both perspectives. This book is a real how to do it. Like, it literally says, step 1, do this. Step 2, do that. And I'm sorry, the good news was that the Planning Act has just come in, but the bad news is that this book still relates to the Sustainable Planning Act. I would urge you to have a look at the Environmental Defenders Office website, Queensland or elsewhere. Have a look at the excellent video that we had last year or a couple of years ago involving the Environmental Defenders Office, and put your name down to acquire this when it comes to the next edition, or if you want to buy this one in the meantime. I think it's about $40 or $50. It's really good. So that's kind of a hybrid. So when you're reading the cases, I want you to think backwards. So if you're reading a Court of Appeal decision about Planning and Environment Court appeal, ask yourself, what would have led to this getting to the Court of Appeal? Same applies when you're reading a case in the Planning and Environment Court. Ask yourself, what would have led for this case to be in this court now? And picture yourself as being the lawyer involved in the process of advising the client to proceed, and think to yourself, how would I do that? What forms? How much is it going to cost? How long is it going to take? Some idea of the process. So during this course, because I aim to make this practical and aim at people that wish to practice in environmental law, we really need to look at some of the nuts and bolts. That's why it's not just a matter of knowing the international theories. It's not just a matter of knowing the overriding legislation, but you must know things like the practice directions, the regulations, and some of the information that we'll give to you. Now, I don't want to scare you off, but we do want to make it so that it's actually useful. I went to the University of Queensland, and I would never disparage that institution because I'm very proud to be a graduate of that university. However, the fact is, in my experience, and I think many of my colleagues, after spending, I spent like 7 years studying there, and I walked into a law office and I didn't know how to do a will. I didn't know how to do a conveyance. I didn't, I had all the theory. If a client came in and said, please explain to me the nuances of incorporeal hereditaments, I could answer that question, but they didn't do that. They came in and asked me to do things like, prepare a will. So what we're trying to do here is make this practical as well as theoretical. Okay, so that's the first assessment piece. Let's share the screen again. I hope you don't mind doing this with me, but I just want to make sure that you're aware of what you need to do to pass the subject and learn from it. So the 11th of January, the second assessment, 2 weeks afterwards. So it's really bang, bang, but you've got a long time to prepare for this. This second assessment deals with the Townsville Port Expansion Project. This is heavy duty, large scale environmental applications, and we're primarily looking at this from the executive, from the regulatory authorities' perspectives. So as part of your reading, you'll need to consider the environmental impact statement summary. You'll need to consider the terms of reference. You'll need to consider the application that was made to the Department of State Government Coordinator General's project website, and then answer some questions. The questions are really quite simple to answer. You won't find this exercise difficult, but what I want you to do is actually, you're gonna squirm when I say this. I actually want you to enjoy the process of looking behind the scenes a bit. Okay, you might see the news, and you might hear about the Townsville Port Expansion Project in a snippet of news. Here's where you get a chance to look at the actual documentation that is before the regulatory authorities in relation to these things. And when you're reading it, it'll start to tie together. We mentioned that the Commonwealth has a role to play. The states have a role to play through legislation and through the executive. This exercise, the second assessment, ties it in together because we actually get to see how the regulatory authorities at state and federal have to work cooperatively. So when you see something like a reference to bilateral agreements and the bilateral agreements regime, think back to the COAG meeting in, I think, Brisbane in '92, where the states and the Commonwealth said, let's stop fighting, let's start to work cooperatively together. And that's where they came up with some of these ideas. So you'll see consistent references to environmental impact statement. The Commonwealth and the states, they don't want to have to do their own, like each one. So the bilateral agreement provides a mechanism whereby, for example, the states can do the assessment and the Commonwealth can use that information rather than both of them doing it. There's a lot of, I don't know, terms, acronyms, things like CAP matters of CAP national, CAP environmental, CAP significance. So when you see a term like that, just stop, maybe, I hate to say it, Google it if you want to, but just try and get a better idea of where it all fits in. Okay, so I think you'll enjoy that process. And then the third assessment, I'll share the screen again. And I'm sorry to keep you so long, but we'll wrap up soon. Let me see if I can share the screen once again. All right, can you see the Moodle site? And the third assessment. Did anyone look at that and think there's something wrong here? Assessment number 3, at-home paper or take-home paper, released on Friday the 9th of February at 5 p.m. You have 3 hours duration. Upload your answers by 8 p.m. on Friday the 9th of February. No acceptance of late work. Now, there's nothing behind that. You don't know the exam questions yet. Did everyone notice that? Did you think, okay, so what do you think you need to be doing at 5 p.m. on Friday the 9th of February next year?
Be at home.
Yes, to be at your computer, be ready to go. Was it cruel of me to make it a Friday evening?
Absolutely.
Absolutely cruel? Yep. But look, there's some rationale behind it. The rationale is that it's Friday night at 8 o'clock, you are finished. And if you're like me, you'll go and have a nice cup of tea and watch a movie at home. Or you can say, that's great, I finished that assessment. Now I can go out and meet my friends, if that's what you're into. So please excuse me for making it a Friday evening, but it was quite intentional. And what's unusual about this is you've only got 3 hours. So take-home papers that I've said in the past, I've given people up, 2 days. But this one, you've only got 3 hours. So it's like an invigilated exam. Pretend that you're sitting in a site, but you've only got 3 hours, but you've got full access to the internet, and you just upload your answer from your own computer. Is that okay? Will that work? All right. So make sure that you have that in your diary and work your commitments around it, because I can't give extensions for at-home papers. So I don't have that authority. I can give extensions for the other two. Good luck trying if you want to ask for an extension, because I'll say, but didn't I tell you on the 7th of November that your assessment was due on the 11th of January? You've got plenty of time to do that. But you can try. You can apply for an extension for the first two. The third one, I can't. So just please make sure that we're there ready to go. Yeah, and it's better than having a 9 a.m. exam at a centre an hour and a half's drive away. And that's the idea. That's what I wanted to do by this. So we're just a small group in environmental law, so we can do a few things that are a bit different to the Priestley 11 subjects. Okay, you've been very patient with me. I know it's been a long session tonight. We have a lot to cover. I wanted to show you some other things. We'll do that next week. Are there any questions before we wrap up for this evening? All good? Okay. So read Bates, but do so fairly quickly, at a fairly lively pace. Use a highlighter, whatever it is that you do. You can buy an online version of Bates if you prefer the digital version. Listen to my commentary about Bates, and that might just help reinforce some of your thinking on chapter by chapter. Read the study guides, of course, but be aware of going to the legislation, going to the regulations, going to the practice directions, and we'll look at more of those things each week. All good? All right. Thank you. No questions? Fine. Okay, well, I'll end the meeting for tonight. Thanks very much, and we'll see you next week. Bye.